join us. Mr. Domina, good morning. Let's give everybody a chance to get in and out. And we're still working on that. You may proceed.
Thank you, Your Honor. Good morning, Your Honors. My name is Dave Domina. I'm here on behalf of Thomas Stalnaker, who is the receiver appointed to receive the assets of the other named plaintiffs in this case. He's acting on behalf of the Securities and Exchange Commission of the United States. This is not really a case in which a lawyer is suing a client for malpractice. It is a malpractice claim. The difference between this malpractice claim and one where a lawyer is suing a client is that...
A client suing a lawyer?
A client suing a lawyer, thank you. A client suing a lawyer, I think I said it wrong twice. I meant it correctly twice. The difference between that case, which you correctly characterized and I did not, and this one, is that in this case, the receiver cuts through the problem of the lawyer and the client being complicitous in wrongful conduct. Here, the recovery does not go to the client. It goes to the persons harmed by the joint conduct of the lawyer and the client.
Could
the
it
failure
conceivably go to the client, some of it?
I don't think so, Your Honor, and I think that there are two things that prevent that possibility. Number one, the argument is that the amount of the judgment could exceed the amount required to make the receiver whole. That's not necessarily true because that can be guarded against by the trial court at the time there's a judgment. It can be guarded against upon submission to the jury. It can be handled like a cap in a medical malpractice case. There is no assurance here and there is no likelihood here that Mr. Behrens will realize any benefit from this. Number two, there's an argument made that if there is a recovery by the receiver, Mr. Behrens will get credit against his federally ordered criminal restitution. That's not true. The federal judge can decide whether this recovery is worthy of consideration as restitution. The federal sentencing judge decides what qualifies as restitution. This is not necessarily restitution at all. It's not something Mr. Behrens brings in for application against his sentence. The receiver brings it in.
Right. So if the receiver stands in the shoes of the investors, and that's your position.
It is.
And is bringing a legal malpractice case in that context, could the investors have brought their own legal malpractice case against the lawyer?
No.
Under Ames Bank versus Hahn?
That's correct.
And so if they could not have done that, if they would not have had standing to pursue their own negligence claim, how does the receiver standing in their shoes do so?
The receiver acts, Your Honor, on behalf of the injured victims. He stands in their shoes to receive the recovery. He assumes all of the rights and all of the privileges and all of the claims, including malpractice claims, of the client who injured the victims.
As an asset.
Absolutely. In other words, if Bernie Madoff could not sue his lawyer because of the doctrine of peri delicto, but there is a mass of injured people out there, the receiver can take Madoff's claims, assert them against the lawyer, but not for Madoff's benefit, for the benefit of the people they hurt together.
Because it is in effect their asset.
It's their asset.
Which they come to learn of later.
Which they came to learn of later, and Madoff holds the claim that provides the conduit to get from the claim to the assets which make the victims whole. That's what we seek to do here. There's a federal statute, 15 U.S.C. section 77T, that specifically authorizes that. The federal court expressly appointed the receiver to undertake this action, and others that were available only by taking Blunk's or Behrens' claims against away from him.
But
that was done.
Wouldn't the cause of action still have to be maintained by the client, and the receiver would come in only if there's a recovery on that type of claim? I mean, really what you're saying here is the receiver is acting for these investors as a real party in interest in a legal malpractice claim. That's your position?
That's really true, Your Honor.
If only the client can sue the lawyer, how can that be? How can the receiver be a real party in interest?
I think the answer is because of 15 U.S. Section 77T and the case law that has developed around it. I recognize entirely that this claim would not be assignable. I recognize that only Mr. Behrens could bring it in other circumstances, and I concur with the court in its analysis on that point, except for the unusual and extraordinary circumstance created by federal law to facilitate exactly this kind of problem in the securities area. And I'll tell you why I think that developed. In 1941, when the Securities Acts were less than a decade old, the United States Supreme Court had an issue somewhat like this before it. We cite the case in our reply brief. And the Supreme Court said, look, the only reason we have securities lawyers is because they're supposed to assist us in enforcing the law. They are private enforcers. They're to help assure compliance with the law so people aren't selling securities to unsuspecting victims they shouldn't be selling. And because that's so, when a lawyer gives advice that facilitates a client's securities fraud, then we're going to allow the SEC to take exactly the position that is being taken in this case. And if we did not do that, then this appropriate bar that precludes a client, once removed, in this case a client of an investment firm, from suing the lawyer who gives the initial malpractice advice, would forever allow the lawyer to escape.
It's not an SEC enforcement action.
It was in the United States District Court, and actually at an agency level there were enforcement proceedings. In federal court, where this appointment occurred, there was an injunction issued. The injunction was an enforcement action in the sense that it precluded further activity on promissory notes, and it stopped the injury.
So focusing on this piece of the puzzle.
It's not.
Could we switch to the statute of limitations?
Yes, sure.
You filed your complaint on December 4th, 2008.
Yes, sure.
And you allege that you didn't discover it until December 7th of 2007. So,
correct.
According, you were within the time frame, but the trial court found that you should have discovered it in 2001 because of some letter from the banking department and an investigation. Now, would that have put your client on notice?
Your Honor, the 2001 letter from the banking department was directed to Mr. Behrens, who is the wrongdoer here for whom the receiver acts. That letter said, you are hereby informed that we are aware of circumstances that may constitute a violation of the law. We are investigating this. We direct you to send us this list of items. Behrens went to his lawyer, Mr. Blunk, and said, what do I do with this? Mr. Blunk took over and responded for him and made submissions to the department. When I asked Mr. Blunk in his deposition, did those submissions, which included a rescission offering whereby he went to the investors and got them to sign off and say, I don't want to rescind my investment, I've been informed of these circumstances, Mr. Blunk said that solved the 2001 problem. And that's what he told his client. But in April of 2003, the banking department wrote another letter on this subject, this one to the lawyer, and said, we're not going to proceed with this investigation, but what you've submitted did not solve the problem. So advise your client. Neither the lawyer nor the client, Blunk nor Behrens, testified that Behrens ever heard of that letter, and Behrens absolutely denies he ever saw it and was assured that he was on the right path. After April of 2003, the lawyer, Blunk, borrowed money from Behrens that came from the proceeds of the illegal promissory notes that are the unregistered securities. So we contend that the statute of limitations is not a bar here, and that this is a case very much like Bellino versus McGrath North, the difference being that here The continuous representation was outside of a courtroom. It was inside one in the Bellino case, and it was inside the context of a very intensive ongoing lawyer-client relationship involving what Mr. Behrens testified in Exhibit 120 was as many as 3,600 telephone calls over the time period involved, and at a meeting and a half a week, 900 and some meetings that the two of them had.
When do you allege or think that the lawyer-client relationship ended?
We think, Your Honor, that the lawyer-client relationship ended no later than December 7 of 2008, when the new lawyer-client relationship with Mr. Dalk started. There is evidence of continuing service into March, maybe even April of 2008, where Mr. Blunk continued to service Mr. Behrens' corporations. But I think there's a good argument that it ended when the new lawyer came in, became involved, and said, this is a problem, and that part of the representation stopped.
How far does the continuous relationship go? Does it if you're just the client's lawyer, or does it have to be the lawyer on that specific issue?
It has to be on that or a closely related issue. And in this case, as you will see from the chart that I put in the brief and from Mr. Behrens' affidavit, all of the service that was rendered by Blunk involved the formation of corporations, advice about how to raise money, advice about how to use promissory notes to raise money, and when and what to register as securities. Blunk holding himself out to Behrens and others as a securities law expert. So we think that the nature of that relationship was around Mr. Behrens' core business, which was the business of raising money with promissory notes to invest and reinvest in other things, all of the time the loss getting bigger, but the new promissory notes being used to pay off the old ones in what became a classic scam. We ask that you reverse and remand. Thank you.
Thank you.